Abusia, and more about and over daily update TV so. Let me ensure say only a dijumasronko. Na ninyina Martin Martin Pegbu okupie PM Express Advanced and host to for credit my joy news. Or na nsem we nyina epie. Na ninyina ne say Supreme Court at the ruling amba. Now ruling and Supreme Court at the by and say Speaker the declaration unconstitutional. And lawyer Martin Pegbu say on say over the period in assembly because Supreme Court to be NPP because Supreme Court to be they normally win the case. Win at to force the enkwana here at DB at say NDC winning. The Omodebe case called to be winning. And like I say national security can the national security for Abekasa. Say Supreme Court also gives ruling winning in the favor of NPP. Then the outcome will be a security threat. Yeah, the security threat. It will be against the national security threat. Because whereby we have a Supreme Court as an institution packed with NPP judges or NPP appointees. And for that matter, when any case enters Supreme Court, the probability of NPP will win is 99%. Until lawyer Martin Pegbu meram ni awajidin lawyer Martin Pegbu chese. We ni pakesi pa na kasa semse. We a national security threat. And you know neka but national security minister is Kandapa and a bekasa seven. Intino basically Kesi bia na say NPP berene and NPP berene and the outcome is a very serious security threat. They release more info on lawyer EDG Tameku Legal Directorate for NDC Legal Affairs. I'm releasing more details at the Kasan same way because in some na abano one they say Speaker at the ruling amba they are a separate institution. The speaker and the parliament house is a separate institution. So say the ball is in the court of the what speaker of parliament. Say abambabing as well objection by the standing orders in the house are Yenshe and Sama Iran. So the Bebanti for now only the Supreme Court ruling no about say the declaration of the sitting is unconstitutional and the lawyer Martin Pegbu says this is a national security threat. It's not only basically, but the national security minister, and so any the fresh in some way about one thing.
Speaker, beyond that statement, has Speaker done any other thing? Did Speaker say today NDC majority? Did Speaker say from today, NPP MPs minority? So please, you see, you people have said a wrong question, and you are helplessly looking for an answer. In any case, where in the stay granted by the Supreme Court, did he say that going for the NPP led by Akroma constitute the majority?
But the stay did not have to say that. The stay. What was the stay about? The stay. What was the Supreme Court staying? The Supreme Court was staying the Speaker's decision to declare seats vacant.
I have a copy of the stay. Nowhere in the state conversation now from the orders to effect. Please, you see the last time during the proceedings that the profound state, they said the country is divided. And that parliament is not sitting. Mr. Sorry retorted, her leadership, is this youth about getting going to sit? What was the answer this gave? You see, it appears that the real intention for going to court is to get parliament to reconvene and not the belief that
what it is that what the speaker has said is in cahoots with the executive. And so, having said so, it means that he is probably deliberate and not going into the court. That is to say, not making sure that the statement of case is filed, because he knows what he's talking about. Then I joined it with the fact that the Chief Justice herself is enough. Very clear, it's incontrovertible on 2 occasions at least. One, at her vetting, when she was asked, in this whole constitution, what does she want changed? The first thing she mentioned was that she doesn't want the president to have a role in the discipline of judges. Obviously, because it enables the president to impact here at the bar conference in Cape Coast. She mentioned that the executive refuses to release money to the judiciary, and that affects the efficiency and effectiveness of the judiciary. So what is that? Control. So when you put this together, you find a statement by the speaker that there is collusion, there's no independence. You find it justified. So when it comes to separation of powers, it's buy one, get one free. So when you become executive president of Ghana, then in that case, you get to control the judiciary. So straight. The executive is always interfering in the affairs of the judiciary, always trying to influence judges. Listen, we have to pay with all the strength we can. It is not new. It didn't start today. It's always been there. So the president's power to appoint judges of the superior court.
But I'm curious, Martin, what has that got to do with today's outcome?
Oh, so we are talking about
goodness.
We find an analysis that the executive is always trying to control the judiciary. If you find thinking that it is the control that is producing that result, very fair assumption. Very fair. I'm not adding anything. We are using the Chief Justice's own complaints and wishes about constitutional change to make their analysis. I've not added anything. I've not added any personal opinions. We are talking about there is not independent enough. Using that to arrive at the conclusion that, then we've set a decision, somebody, that is to say, reversing the speaker on the vacation of the 4 seats, somebody can assume that it is the control that has yielded such a result. It's a fair assumption. If we didn't have the basic facts of complaints of the executive controlling the judiciary, then that's when you cannot make any inference.
I mean, I'm curious though. I'm curious. Are you suggesting that
the basic facts?
Are you suggesting that today's outcome is also one that is because of that control?
Oh, Evans, once winning all the cases, national security is a national security threat. For the national security minister to tell the judiciary, Evans, I'm not happy to do this, but we are analyzing basic facts. If you had told me that, Martin, it is not true that the Chief Justice said the president should not have a role in the discipline of judges, and number 2, Martin, it is not true that the Chief Justice complained that the executive, that's the president and his ministers, refused to release money and thereby seek to control the judiciary, then we couldn't have laid anything on it, because if there's no foundation, you can't lay anything on it. But once these 2 basic facts are true, then it's a fair comment, which even the Constitution allows.
Those facts may be true, but is it true in all cases that the Supreme Court hears? I guess it's the way I find a challenge with the argument that because one, there are issues with the independence of the judiciary, and many surveys have shown that. Then all cases that come before the Supreme Court somehow have been sort of impacted, tainted by the lack of independence.
Evans, obviously, I'm not one to make such a statement. Evans in the Supreme Court. Oh, Evans, I've done 17 years in the court.
But you're applying it. But you're applying it. Yeah, I'm asking because you're applying the principle to this outcome, and it may be wrong.
Right. And to every rule, there is an exception. To every rule, there's an exception.
And today's outcome may be the exception.
Don't forget. Of course, I can grant you that. It's not a problem. I can.
Oh, goodness. I apologize, Martin. You accept them in good faith?
Evans, we are analyzing facts. I'm surprised Frank Davis is gone out to town with all those statements. We are analyzing based on facts. This is logic. You cannot exclude the inferences I'm making. So if you understand logic, I've said nothing new. It's all within the logic of the statement. So I'm surprised he's saying, will I go back to the court? I was there 2 weeks ago. I was in the Supreme Court on the 30th of October. I have a case. And the next time they invite a better constitutional review. We want to take away the powers of the president to appoint the judges. It's very critical to our democracy. So Frank Davis should stop playing ostrich. We want a better constitution. So let's face the facts. We have to take the bull by the horns. Let's stop playing ostrich. So it's not within Frank Davis to ask me that will I go back to the court. I've been going there. I was there on the 30th. I haven't scandalized the court. We are doing analysis based on publicly available information. I've not come with any personal inferences, right? Once the basic facts are allowed, the Constitution says I can have a fair comment. If you have disputed the basic facts about the Chief Justice complaining about executive role and the discipline and other issues of judges, then Frank would have had an issue. But Mr. Davis cannot dispute that.
Okay.
So please, let's stay within the facts.
Yeah, Martin, thank you very much, and thank you very much.
Abusunya a daily update TV so na wo hwedu medina eni die kwa so na o subscribe am YouTube channel no. O subscribe ya na o like na o share. Ni nyina e nsema omode abem. Se enra ana ruling ni bae. But ni nyina ne se the details of the ruling no and drop it etene na omobe den. Omobe drop the details of the ruling na eba enra no. Chese ni nyina ne say 5 out of 2 7 no 5 actually say the speaker ni unconstitutional and 2 and so depend yura speaker but ni nyina ne say because the majority carry the vote into no ni nyina ne say tinton time ne say speaker the ruling no is unconstitutional because it's got 3 supported yura afenyo markets ebusia mame for 1 years.